If you're charged with a drug crime, it's going to depend on the type of substance that you had and the quantity of substance that you had as to the seriousness in terms of its penalties. In Ohio, we have Controlled Substances Act, which designates a drug as either being a Schedule 1, 2, 3, or 4 substance. A Schedule 1 substance are classified as more serious because they have no medicinal value. Also, the quantity of the drugs makes a huge difference as to what the felony level that you're going to be facing, which correlates to the potential penalty range. There are also different types of drug offenses. There's drug possession, which is the mere either actual or constructive possession of a narcotic, or alternatively, there's drug trafficking, meaning that you are distributing, selling, or have the intent to sell a substance. It doesn't matter whether you're in possession or whether you're trafficking, they are pursuing drug crimes aggressively for both. On the possession side, you're usually talking about law enforcement targeting lower level users, and there's a purpose for them targeting lower level users, and that their intention is to sometimes use these individuals that have drug problems and see if they can't flip them to become confidential informants or snitches or perform controlled buys to get to a drug trafficker. So it's common for law enforcement to sometimes pick on the low-level user in an attempt to use them to get to the source of drugs. Common ways that they will do this is telling them that they won't go to jail if they speak to law enforcement, if that they simply do some things for them that they won't charge them with the crime. And this often squeezes a user into agreeing to do these things for law enforcement. This leads to drug crime investigations for drug traffickers. And this is the most common way that drug traffickers are investigated and eventually arrested.